Yes. Come on, call out. You don't have to wait for them. You just call, they will be ready. Okay? Yes.
May I please, Your Lordship, pleadings have been completed.
Oh. Mm. Yes. So,
My Lord, by filing this writ petition, we are challenging the detailment order dated 25/6/2024, issued by Kala Sir Chief, which is the Deputy Commissioner, which is at page number 57, my Lord. This is the detailment order for conducting eviction drive.
page 57.
Page 57, Annex 14. Whereby the
Wait. Let me come to you. There's no page. Okay, yes. Detailment order.
yes,
Oh, yes.
this is for eviction, eviction of the petitioner
Last year.
from, yes, my Lord. And this detailment order has been stayed by this honorable court. We are seeking, the prayer is for setting aside of this detailment order and for protection of the building, the residential building of the petitioner, from being demolished by the respondents. My Lord, the facts of the
Why?
case
Ah.
is that the land and building of the petitioners was acquired for construction of National Highway from Aizawl 2 to Ipang. And assessment of compensation was made for the building and also for the land. But the the building was underestimated by the Kala at the time of making 3G award, my Lord. The asset value, that is the value of the building, was assessed as rupees 12 lakhs 60,156, which can be seen at page 17, my Lord. Page
Yes.
17, Annex 4 is the assessment, inclusive of the value of land and the value of the building. The value of building is at column 9, my Lord. 12 lakhs 60,156. Being aggrieved by this underestimated value of the building, the petitioner has submitted a complaint to the concerned authority, that is the Kala, Deputy Commissioner Sir Chief, which was appointed by the Ministry of Road Transport and Highways to act on behalf of the ministry to determine and survey the land and determine compensation payable to the petitioner. Then, my Lord, after submission of a complaint by the petitioner, reassessment was made, which is at page 18. 18 to 20. Page 20 is the assessment sheet, my Lord. The value of the building was enhanced from rupees 12 to 18 lakhs.
Okay. Ah.
It means that it was enhanced by around rupees 6 lakhs.
Oh, okay. Very good. Then?
6 lakhs 38,195. Then this,
So you are satisfied with that amount?
yes, my Lord.
18 lakhs. Okay. Then?
Yes. this assessment was forwarded to the NHIDCL. White letter dated 4/4/2022, Annexure 6, my lord, page 21. Then in reply to this letter, my lord, at page 22, if I may read, my lord, this
Yes.
letter of the General Manager, PMU Selling of the National NHIDCL, my lord. If I may start from para 2, my lord. In this regard, it is to submit that as per National Highway Act 1956, the KALA is entrusted to determine the beneficiaries and also the amount of compensation to be paid to them in respect of their land, assets to be acquired for the purpose of upgradation of National Highway. Hence, we request your good office to do the needful in this regard. And if found eligible, the individual may please be paid compensation from the amount already deposited by the NHIDCL to the joint account of GMP and KALA. This is the response given by the NHIDCL to the KALA. However, this was not paid till date. And being also aggrieved by the value of land assessed by the KALA, the petitioner has approached the arbitrator. And the arbitration case was disposed on 22/3/2024, which is at page 29, Annexure 13. In the relevant portion, operative portion of the arbitral order is at page 26 and 27. Well, this arbitration case is filed by not only by the petitioner, but by others petitioner as well.
So it says that you shall be paid the amount as reassessed.
As
That
reassessed.
means additional 6 lakhs.
My lord, along with statutory interest is, yes, my lord, that reassess amount along with interest, statutory interest as per law, that is solatium and interest, 12% interest should be paid to him. And even at the time of hearing before the arbitrator, there was a verbal submission and assurance given by the NHIDCL. Because they want to demolish the building, then the petitioner's representative insisted that before demolition of the building, the
Full amount
reassessed
should be
amount
paid.
has
Okay.
to be paid.
Yes.
This
Then,
is the specific direction given by the arbitrator at para 6 and 9. Then the prayer in this writ petition before this honorable court is protection of the building until payment of the reassessed
Okay.
amount.
so then, what about the state or
Respondents,
NHIDCL? You have to give the payment then. Yes, anything else? So this page 14 is a drawing of the building, is it? Page
Yes.
14?
yes, my lord.
This one with the roof and half brick.
Yes, my lord.
Building.
This is semi
So-
RCC building.
Okay, so if this is demolished, the road is going to be much wider along this curve of the road, is it? It can be extended.
What we are praying is that before demolition of the building, the reassessed amount has to be paid. Let the amount be paid in full.
Yes, so what
That
is
is
the
a-
submission of the respondents? Are you going to pay or what's happening? Simple matter. Have you paid? No. 6 lakhs with 12% interest.
May it please your lordship, on behalf of the respondent NHIDCL, my lord, although as per the submission of the learned counsel, the reassessment was made by KALA. Now, if we going by the National Highway Act of 1956, my lord, it doesn't empower the KALA to make any reassessment. If I may kindly draw your lordship's attention to the Section 3G of the National Highways Act, my lord.
But you had also gone for arbitration, isn't it?
They had gone for arbitration.
Award is already there.
The award is there, arbitration is under appeal, my lord.
Oh, it's under appeal right now?
Yes, my lord.
Then you'll have to wait for the appeal
Outcome
to
of
be
the appeal.
outcome. At this stage, filing a writ petition,
My lord,
at
we
the
are
most, it is the staying of the,
not only staying for protection of the
okay,
building
so we
from-
can dispose this off,
Yes,
saying that the building should not be demolished till the disposal of, till the what? Disposal of the appeal which is pending.
Your lordship,
There is a prayer, my lord.
we are having a problem to the stay, which is in play as of now, my lord. Because this is the only building which is delaying the project. Now, as your
Then
lordship
I
clearly
think you
knows,
should approach the district court where the appeal is pending against the arbitration judgment. Okay, you have gone and appealed against the, then I think the appropriate court would be the the court of the district judge concerning whether it should be stay or not, since the matter is pending before the district judge.
My lord, the petitioner has not yet received any kind of summon from the court. Whether the appeal has been filed
What
or
is the
not,
stage? What is the stage?
is not known to the
Then
petitioner.
please update the petitioner what is
we have served him
happening.
a copy of the affidavit in opposition, my lord. At page 38 of the affidavit in opposition of the NHIDCL, wherein we have annexed
You
the-
are serving a copy or you have served?
No, my lord, we have annexed the copy of the order of the additional district and sessions judge 2, my lord.
Okay, where's
But-
that?
Page 38, my lord.
So you have a copy, you have received a copy.
My lord,
But from the court of the district judge also, you are supposed to give a copy.
Copies 2 has been given, my lord, towards the bottom.
but I have not received till date from
Then
the court.
you should go to the district court and say that you have not received a copy. And since the matter is pending before the district court, the stay also, whatever, it has to be considered there since it's an appeal against the arbitration.
It's arbitration petition number 17 of 2024, my lord.
So I think we can dispose this writ petition with an order that you are to approach the appropriate forum. And maybe till then, since the court has already passed, where's the interim order passed by this court?
5/7/2024. The first order, my lord.
Whatever problem you're facing concerning this stay, you see, because everything will depend on the outcome of the decision of the district court. So the High Court interfering at this stage would not be appropriate.
But my lord, the eviction drive, the notice has to be set aside because my building has to be protected.
It can be set aside by the district court because you are appealing against the order of the arbitrator.
No, no,
Isn't
my-
it?
my lord,
They are
We are
appealing.
appealing.
Huh, they
I'm
are
not
appealing.
appealing.
So as per the order of the arbitration order, it says the amount should be paid.
My lord,
Now they are challenging that, saying we don't have to pay the amount. That is being challenged before the district court. Then in the meantime, this matter also will have to be placed before the district court. It
My
is
lord.
for them to see, isn't it? By looking into the merits of the case, whether your prayer is reasonable or not.
but my lord, until we get the protection from the district court, let the building be protected by this honorable court.
Wait, what would be the appropriate order then? Because how much can we interfere, isn't it? So, maybe we can fix a period, okay, within a period of maybe 2 months, by which the matter should be placed before the district court.
And they should be restrained from demolishing the building.
Till the matter is placed, we'll fix a period of 2 months. Let's see
My
if it's
lord.
reasonable. Okay, let's see, because the matter is a little bit complicated. We will say that the interim order, okay, will, no, the protection prayed for will extend to the, up to a period of maybe 2 months, by which time, okay, the petitioner, giving time to the petitioner, okay, to approach the district court, okay, and raise the issue concerning stay of the eviction before the appropriate forum.
My lord.
Your
Okay, wait
Lordship,
is pending. I think then it will be safe,
If I
huh?
may, my lord, everything is on record. The reassessment amount is also already there, my lord. Now,
But,
the with
But they
regards
don't
to
want
the
to pay, my
protection, my lord, even if the building is demolished, and if so, he is entitled to receive the reassessed amount, it's still there. It's not going anywhere, my lord.
But he
What
has his,
our concern is-
so let him place that before the appropriate court, because you have gone to the district court in
Your
appeal.
lordship, our concern is the work is being delayed. We
Right,
have a
right.
completion date, and that, my lord, the monsoon is about to start, my lord, which will further delay the national highway project, my lord.
My lord, this is not a big,
If the arbitration
amount.
petition is
It's only six.
decided within 2 months, that'll be enough, my lord. The amount, the reassessed amount is not going anywhere. Everything is there, my lord.
Yes, I think if you are entitled
He'll
to
receive,
the
my
money, you'll receive it. If you are not
My lord-
entitled, you'll not receive it.
My problem is, my lord, the amount that has been paid to me is not sufficient for
I think
reconstruction of the
we
building.
will leave it to the court to decide, maybe within a period of, we'll give you time.
My lord.
If 2 months is too long, maybe 1 month. Okay, by which, since the, now you know about the matter which is pending before the district court, though you say you have not received a copy in the affidavit in opposition, it's already been laid out. Okay, so we'll give you some chance within a period of 1 month. It will extend the interim order by which you'll have afforded enough opportunity to approach the district court whether it should be stayed or not permanently till the payment or whatever, or the disposal. That I will leave it to the discretion of the district court.
My lord.
Okay, because now the arbitration order for payment of another additional 6 something lakh is under challenge.
Yes, my lord.
Huh.
Now the project is being stalled only
So,
because
so
of this. my lord.
in the hearing itself, it can be disposed of. If the court will decide whether 6 lakhs is to be paid or not as per the existing laws, and then it can be disposed of.
If the stay is
straight away.
lifted, my lord, we can start working.
So we'll give you a period. Then you can pray for the. So it's only for 1 month.
My lord, the rainy season is coming.
My lord, this
It has been
pertains
kept
only
pending
to
for so
this
long.
small
So we'll
amount
dispose
for
of-
the
we'll dispose-
NHIDCL, my lord. If they
But
pay,
that
we
I'm
can
not
double
going
it.
to interfere. Small amount, big amount, that's the decision of the now the district court, since it's there.
My lord.
Okay. Then if it is not, then it is going to be the stay order will be vacated after 1 month. Okay. By that time, if you want an extension, whatever, that's up to the court now. You will not interfere there. Yes. I'll pause the order accordingly. Disposed of.
Obliged, your lord.
Yes.
Item 2.
Yes.
Lordship, I'm appearing on behalf of my senior CGC. May I seek another 2 weeks' time for filing affidavit in opposition, since our draft affidavit is not yet returned from the vetting authority.
How many times are you going to pray for filing of your counter
Lordship,
affidavit?
May I
Yes.
please, Lordship?
Yes.
Lordship, 2 years completed, Lordship. Till today, they are not able to file it, Lordship.
We
The
give
question
you
is,
some
Lordship,
chance. What is the matter about?
matter is pertaining to the, my Lordship, construction of the Indo-Bangladesh border, Lordship, in the district of Mamit, Lordship. Lordship, earlier also, Lordship, in the order dated 23/1/2025, Lordship,
Have you contacted the concerned person?
Yes, my lord.
What do they say?
We already sent our draft affidavit for vetting, but not yet returned till date.
Okay, it's been sent for vetting.
Yes, my lord.
So some steps are taken, isn't it? Anyways, Mr. Your good
B.
name?
Chakma, Lordship.
B.
B. Chakma.
Chakma, learned counsel for the petitioner, is present through VC, while Miss Baby Laldan Zwali appear on behalf of her senior, the learned CGC, Learned Counsel for respondent number 2 and 3. Is it?
Yes, ma'am.
The Learned Counsel for the respondents has prayed for a further time to file their counter affidavit by submitting that the draft affidavit has been sent for a vetting and the return of the seed is still awaited. How long it will take?
3 weeks, my lord.
In view of the above, after 3 weeks. Yes.
So there is also interim order, Lordship.
Is there one?
Interim order to be continued. Interim order, Lordship.
Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Item 3.
On behalf of Lordship.
Your Lordship, I would like to tender my sincere apologies, my lord, in the matter of today's I was given a last chance to file affidavit. Attempt was made to file the affidavit today, but then there is some correction that needs to be done. Now, attempt will be made to file the same by the end of the day or tomorrow, my lord.
Here, failing which the prayer for, so you want to withdraw the writ petition or what?
Yes, my lord.
Your Lordship,
Let them withdraw, what do you have to say in this
Your
matter?
Lordship, the question is that they have withdrawn the money that is for the tourism department, because now they are stopped from saying that because they have already consented to it has to be portioned between them.
My lord, as per the last court order, if the respondent number 4 had not filed her affidavit in opposition, failing with the prayer of the petitioner for withdrawal of the repetition is allowed, and
There's
therefore
an order already.
Yes, Your Lordship, I understand, but I'll be filing it by end of the day or tomorrow, Your Lordship.
Lordship to make a decision as per the last court order.
We'll list it tomorrow, subject to you paying a fine of rupees 5,000.
Your Lordship, today is not end yet, Your Lordship. So if I may be allowed
Okay, you'll
to,
be filing it with the course of the day. Okay, we'll make it the time being, it will be filed during the course of the day.
Lordship, the last court is on the month of March, and 2 weeks is already lapsed. And if they are not ready till today, it is liable to be
We'll give them
done
time.
by.
We'll list it
Yeah.
tomorrow. Okay, we'll list it tomorrow. If it's not ready by that time, then we'll list thing. Okay, since she's saying that it's ready, it will be filed today, then it can be listed tomorrow.
Lordship, it is.
Don't be
Lordship,
so
the case.
scared. You don't have a good case or what? Don't be scared.
No, it is not like that. No, we are waiting for a long period for.
See, you have
waiting
the money
affidavit.
with you now. You are not
is already-
facing any difficulty, isn't it? Here it says that SBI Klabong branch amount of 37 lakhs has been credited to your account. So the money has been credited to your account. It's there with you.
it was there with them, it was froze by the SBI now.
It is already withdrawn, my lord.
It's so
But
with you.
hence-
So you're
but
not
hence
losing
left, yeah.
anything, huh? So if you have a good case, the money is been withdrawn by you. You have the money, okay? And if you feel that you have a good case and you don't have to pay anything to the respondents, then you just relax. We'll list it tomorrow.
Lordship, my prayer is regarding the unfreeze of my account, and this honorable court allow me to operate my account.
Yes, very
and
good.
for a long time, waiting for filing the affidavit.
So what about the 37 lakhs which is mentioned here?
37 lakhs is my compensation, which was credited to my
So
account.
it's
yeah.
with you now. 37 lakhs has been deposited into your account, isn't it?
Yes, my lord.
Yes, so it's yours. So now you feel it's yours. Now we have to see whether it has to be also what?
Lordship, this is not the first time I think given last chance for filing affidavit in
So
opposition.
tomorrow, positively, if they have to file today, okay? Heard Ms. Jacintha Zo Thanmoy, learned counsel for the petitioner, along with Ms. Mary L. Kiante, learned counsel for respondents number 4. The learned counsel for respondent number 4 submits that despite this court's order dated 11/03/2025, wherein this court had noted that 2 weeks' time, this last para, we just make it with inverted commas, page 38. Okay, so and so. The learned counsel for the respondent number 4, however, praised that the affidavit is ready and will be filed within the course of the day. In view of the above submission, list the matter tomorrow. That is, when's tomorrow? Tomorrow's date? Or,
21.
On 21. Even if it's DB day, after DB, we'll have this matter. Okay.
Yes, my lord.
On 21/5/2025.
Yes, of late.
Yes. You want the names to be reflected? Yes. The others. Mr.?
Hearing for respondent number 1 and 2, Zaudin Namte,
Okay, Mr. So-and-so appears on behalf of respondent number
1 and 2, statement of intent.
1 and 2.
Respondent number 3.
Okay, just make it Mr. So-and-so for respondent number 1 and 2 is present, along with Miss Baby So-and-so for respondent number 3 and Mr. Rokoma for respondent number
number 5.
4. Okay, yes, number 5 are present. Just say, list their names and say are present.
Item 4.
Yes. Yes, oh, this is the matter where last court date you were not prepared. You are prepared now? So basically, this thing is very simple, whether Myanmar is an enemy of the country or not. So it's not. What do you have to say?
Your Lordship, at the very outset, the main points of my argument is that review petitioner, being a foreigner, illegally residing in India without having a valid passport and license, cannot have a right to sue compared to the citizens. And in fact, she is liable to be booked under the Foreigners Act and the passport entry to India.
Foreigners Act, he's booked, or what? This is a money suit,
Yeah, but
not
she's
a
a
criminal.
foreigner.
Okay, okay, I've heard your arguments dismissed. Okay, it's wrong because you're citing the section of the law, okay, which was it?
83 of CPC.
83 of CPC, where it is the enemy of the country. Myanmar is not an enemy of the country. Others, they have the right. Okay. So if this person was from Pakistan, then definitely you have a case because they are in war. They are not in war. So
Your Lordship, on strict interpretation of Section 83, it is seen that only an alien friend can sue. Only an alien friend.
okay, I've heard your submissions. I've heard it last day. Coordinate your submissions. Yes.
Only an alien friend can sue. But in this case, the review petitioner failed to establish
It's an
that,
enemy. You're saying it's an
failed
enemy
to
of the
establish
country.
that Myanmar is an alien friend of India. In fact, Your Lordship, I have the documents, so
Okay.
can you please?
You see, 83 says while they are in war, are we in war? Pakistan, it's a different thing. It's a money suit, not a criminal case,
with your
where
permission,
Section 14 of the Foreigners Act is not involved here.
Your Lordship, with your due permission, let me read out Section 83 of CPC.
Okay. CPC? Visa, no visa, this is a different matter.
This is a very important
Visa, no visa, it's not mentioned. Okay, here you're saying bordering. Bordering, it's okay. Let them make border in the country.
Your Lordship,
Huh.
if I may read out Section 83 of CPC.
83, huh. because last court date also we had heard that matter. And I was going to dispose it off, but since you had prayed for more time. Yes, 83.
When alien may sue,
Oh.
alien enemies residing in India with the permission of the central government and alien friends may sue in any court otherwise competent to try the suit, as if they were citizens of Indian. But alien enemies residing in India without such permission or residing in a foreign country shall not sue in any such court. So what I would like to stress out is that
Explanation?
only an alien friend can sue in the court.
Continue, explanation.
Explanation, yeah. Every person residing in a foreign country, the government of which is at war with India and carrying on business in that country without a license in that behalf granted by the central government, shall for the purpose of this section be deemed to be an alien enemy residing in a foreign country. So, Your Lordship, on strict interpretation of
Which is at
83,
war with India, huh?
yeah. Although Myanmar is not an alien enemy of India, but they are not alien friend. On strict interpretation, it is seen that only alien friend can sue. But there is no official gazette or any government official
So in which
documentation to
is
show that-
alien friend and no alien friend, isn't it? So you're saying it's an alien, okay, I've got your submissions. Okay, I'll pass the order. Okay, dismissed. Okay, and disposed of. I'll pass the order later. I've heard your submission. I've seen your documents also. Okay, your document says the countries which need visa and don't need visa, isn't it?
Your Lordship, I have the definition of war as per the Black Rose Dictionary.
In war.
There are many types of war. There can be civil war, Cold War, and recently, Indian government have a border conflict with Myanmar, which shows that they are not alien friend, they are alien enemy. Although there is no express provisions or gazette. Because see, Your Lordship, I've
See,
already
because we
submitted
have
the definition
so
of
many
war.
cases, okay, when they are also from originating from
Because it
Myanmar.
can lead a bad precedent if a foreigner illegally residing in India carrying illegal business can sue Indian citizen, it will have a great effect, the negative effect, because a bad precedent in the future. Because they are foreigners illegally residing in India, carrying illegally trade in India. So presuming that if the
Is the
foreigner,
trade illegal or not legal? This is
Because-
between two people. They're borrowing money. He wants his money back, isn't
Your
it?
Lordship, they
What
didn't have any
trade?
license to trade in India.
What trade? You're borrowing money and want the money back, isn't
No,
it?
it's this kind of
Yes, my
trade of
lord.
second-hand belt. It's export from
Okay, I'll
foreign
find your
country.
submission. Okay, fine. Good.
Please, Your Lordship.
Yes, yes. So more submissions. I thought you'd made your submissions previously. Anyways, in
Yes, my lord.
rebuttal.
Today, this petition or this appeal is arising out of, review petition is arising out of about alien enemy, not about such illegal trade, and also,
Someone borrowed someone's money, I think. I read it
Ye-
last
yes, my
time.
lord. Yes,
Okay,
my
and then
lord.
you want your money back, and he says you cannot sue or something like that. It's between two individuals,
Yes, my
not
lord.
trade and illegal trade. Is it? What was the case about?
this case is about,
Basically, let's look at the judgment under which
yes, my lord.
the order.
In the para number 2, which was judgment and order.
Alien enemies. It's
Yes,
concerning
alien
alien enemies.
Yes, yes, my lord. In the last part, para number 2, thus submitted that the plaintiff number 1, which is the appellant number 1, revision number 1, revision petitioner number 1 has no local standard to file the instant suit against the defendant. Learned counsel also submitted that the plaintiff number 2, which is the review petitioner number 2, is a citizen of Myanmar, and she is barred by Section 83 CPC to file the suit against the defendant, which is the respondent number 1. So, on that grounds, the money suit number 137 of 2022 was dismissed on that grounds. Then, Section 83 CPC
did not bar a foreign airline friends to file a suit in India. So,
I think I've heard your submission. Her last court date, I think I've heard your submissions.
yes, my
But
lord.
only thing the counsel for the respondent had prayed for time after hearing that he was not prepared with your documents or something. No? You had some documents. So
Your
now
Lordship,
you have produced your
conscript
documents.
interpretation 83, although Myanmar is not alien enemy, but they are not alien friend. And if we carefully read interpretation 83, only alien friend can sue. But there's no proof from the part of the review petitioner that Myanmar is an alien friend. In fact, the recent tension, the border conflict in Myanmar, deemed to be considered as Myanmar is not alien friend of India. So they have the right to sue. So the review petitioner is liable to be dismissed from my point. Your
My
Lordship.
lord, I have a document to
Yes,
to
whatever
do some-
documents you
yeah,
please
yeah.
submit.
I have researched from internet, like Indo-Myanmar relations.
And you cannot get the help of the Home Department also. That's the whole thing, isn't it? You leave it to the court. So the court will look at the documents and decide.
Okay, my lord.
Neither of you have any documents. India, from the, you got this from where? Internet? Google?
Yeah, yes, my lord.
You keep
Wikipedia.
Googling whoever Googles and gets it. It's as simple as that. Okay, fine.
Refer from
Give a copy of your documents also.
34 sources.
Your Lordship, I've already contacted the Home Ministry also, and the answer is that the alien friend of India are those countries, Bhutan, Maldives, and Nepal, which visa entry are, exempted of, so they can enter India without visa. Only this country, Bhutan, Maldives, and Nepal can be considered as alien
That's
friend
the visa or not, isn't it?
because they are not alien friend Myanmar and they have no right to sue in India.
Let's
According
see
to
that
83 of
document.
CPC.
Let's see.
I already submitted this.
Okay, I'll have a look.
Okay.
Okay, my lord. About visas. In the document which I have submitted, page number 5, about visa.
Okay, let her finish her submissions first. I thought we had already heard the matter, but now you're coming with new matters. I thought we'd already heard. I'll hear the respondent and then we'll dispose it off. But since you still have something to say, let's hear your submission. You can sit down.
Okay,
Who
my
is
lord.
submitting right now?
About visas.
Then the respondent can sit down. Counsel. Once she finishes, you stand up. Yes.
About visas, page number 5.
Yes.
Can I read it out? Only
okay, let's hear
only
some
one
more.
line. Okay. During a 2017 visit to Naya Piato, Prime Minister Modi announced that India would offer gratis.
Where are you reading from?
Page number 5.
Of what?
Which document which I have
The document which you just gave me. Is it?
yes.
This one? Page 5.
Page number 5.
Uh,
Visas.
It doesn't have any vegetation, so 5 will be the 5th page.
Yes, 5th page, my lord.
What is the heading? Yes, okay.
During 2017 visit to
Okay, yes.
Yeah. Nai Piato, Prime Minister Modi announced that India would offer gratis no-cost visas to all Myanmar citizens visiting India. So,
This.
Myanmar people will not need no-cost visas for
You got
Myanmar.
this from where? I think we'll have to ask then the Prime Minister. Did he say this? Anything else? Is that it?
Uh, my humble submission for today is that Myanmar is not an alien enemy for India, so they have a right to sue in India. Then I have prayed this honorable court to set aside the imputed order 60/2022, 2024, which was filed by Senior Civil Judge 3, Aizawl District.
Okay. Yes. Then the submission of the respondent is what? From your documents which you have submitted?
Your Lordship, although I accept that Myanmar may not be alien enemy, but they are not alien friend. As
Okay.
per the Section 83 of CPC, it is in that only alien friend can sue. But the review petitioner failed to prove that Myanmar is an alien friend of India.
Okay, she has brought out this thing, document, so we'll have
But
to,
it is-
because,
it is
okay,
not
so
specifically
this
mentioned
is the
here.
document which you say it's not good enough, okay, but she has produced one document, and so I've heard your submission.
Your Lordship, please, the last point of my argument is, you see, the review petitioner is a foreigner illegally residing in India without having a license or passport. So may I, with your due permission, may I read the passport entry to India Act 1920? I've already submitted
It's here with,
the
okay,
passport entry to India Act 1923
you have already submitted?
Yes.
Where?
today itself. Give it to you. The passport entry to India Act 1923. It is only 3 pages. Page number 2, para number 3. Page number 2, para
Wait,
number 3.
wait, list of countries. How many documents did you submit?
I think around 5.
5, but only 2 have been given.
Only 2.
So give all your documents. Only 2, isn't it? These 2?
Sorry, my lord. Is it with me?
It's with you. Yes.
Your Lordship, page number
Yes.
2, para number 3. Page number 2, para number 3. My lord. Power to make rules. The central government may make rules requiring that persons entering India shall be in possession of passport, and for all matters ancillary or incidental to that purpose. And 2A, prohibit entry into India or any part thereof any person who has not in his possession a passport issued to him. And you'll also page number 3, para number 4.
So they are arrested now? Are they arrested?
Oh,
Have they been booked under?
They are liable, she is liable to be booked under the.
Okay, so you take action. Anyway, sir, I'll make it a CAV then. Just leave
I
it.
have one citation, Your Lordship. You know what
yes.
Nkung versus Aral din Puya,
Okay,
you know what
yes.
GLR report 2014, volume 4, page 354.
Yes. What does
Your
it say?
Lordship, it is not exactly similar to that case, to this case, but the foundation of this case is similar. In this
Okay.
case, it is about giving bribe money for procurement of job. And in this case, it is held that page number 2, the paragraph number E. No judgment could have been passed by the London Trial Court on a cause which is illegal and criminal offense. So if the foundation is criminal action or criminal offense, judgment cannot be passed in favor of that particular person. So by relying on this judgment, the foundation is illegal. Foreigners, illegally immigrants entering India without having license. So-
Giving bribe money. So in your case, it has to be an illegal action. Here it is giving bribe money. In your case, what is the illegal action?
because carrying illegally business without having a license or entering into
Is
India.
that the case about illegal business?
No, it's not illegal business.
Then what is that about? The main case. See, this case is about something, bribe money being given. That is definitely
The
illegal.
foundation is similar.
So here, is it bribe money or what?
No, it's not a bribe money.
What is the case about? The main case. Whether they have a
Yes,
right to be a party or not? Is it concerning giving bride or what?
No,
Illegal trade?
no,
What?
it's not an illegal trade.
Then what is it about?
The review petitioner number two had running a business like different kind of shoes like uh, dealing in sneakers, boots and heels.
So what is the main case about, the civil suit? The suit, what is it about? Recovery of money, isn't it?
Yes, my lord. A suit for recovery of 11.
Recovery of money?
Yes, recovery of money from the respondent.
Isn't
It's
it?
not a
So
bribe
we'll-
money.
So we'll have a look whether
They
this,
export from Myanmar without visa or without a license, okay, without any tax. They illegally export from Myanmar.
so what was your part? You borrowed money from them or what? What is your case in this thing,
We carry
instant thing?
business partner.
The business partner, so it's because they want the money to be recovered, isn't it?
Yes, my lord.
So
Then,
the foundation is illegal. The
so
foundation
you're
is-
saying you're not liable to pay because you didn't borrow the money or what?
my main point is she have no right to sue
Then we will leave it at that, okay?
based on section 83 of
Yes,
the
so don't go round and round and, okay? Yes. Heard Miss So-and-so, learned counsel for the petitioner, along with Mr. So-and-so, learned counsel for the respondent. Having heard both the matters, matter is reserved for order. Yes.
Give your bench orders, item 5.
Yes.
Your Lordship, the senior counsel is engaged in some personal, he is having personal difficulties today.
Condonation
So,
of how many days? 2,938 days. So you have to have very good grounds.
if we can take it up on tomorrow,
Tomorrow is DB day. So we'll make
After
it some
DB,
other
if
day.
it is
Okay, yes, Mr. So-and-so, learned counsel, appearing on behalf of his senior,
Sir
Mr. C. L. Ramzawa, learned senior counsel for the applicant slash appellant is present, along with Mr. L.H. Lianshima, learned senior counsel for the respondent number 6. Then, you're for Mr. Samuel L. Tangse,
1 to 4 months.
learned additional AG for respondents, state respondents number 1 to 4 is also present. The learned counsel for the applicant slash appellant has however prayed for adjournment of the matter since his senior is not able to appear today due to some personal difficulty. In view of the above submission, list, when do you want it? In the next week?
if tomorrow is not possible, then next Monday.
Okay, list on Monday. Okay, that is 26th, is it? 26/5/2025. Yes.
Much obliged.
Item 6.
As per this Lordship permission, we have filed our additional affidavit on 2/5/25.
Additional affidavit, huh? So,
Yes.
copy given? It's
Copy
here?
given, my lord. But my learned friend is government advocate is on legs in court number 2.
Government advocate or?
PP.
PP.
Additional PP,
How
sorry.
many additional PPs do we have?
I think 2, man.
Then, so this is the last item. Any other matter?
I think they have just finished. I have been informed they have just finished.
Okay.
If your lordship can accommodate us today or any other day, it will also.
We'll list it on Thursday.
My lord.
Mr. C. Lalpak Zwala, Learned Counsel for the appellant is present, while none appeared for the state opposite parties. State respondent. In view of the above, list on, what's Thursday? 22nd. List this matter on 22nd, 5/20/25.
Obliged.
We have one hearing matter fixed for today.
Hearing item 6.5, sorry.
Yes.
May it please your lordship. This appeal has been preferred against the impugned judgment and order dated 21/10/2021. Passed by Sri J.S. Chakma, Judicial Officer, District Council Court, Chakma Autonomous District Council, Kamala Nagar, Mizoram, in case number 26 of 2020. The grievance of the respondent, who is the applicant oblique petitioner therein, is that in the year 2012, when she went to Delhi,
Where's the judgment?
judgment is after the index, my lord, just after the index.
This is an appeal against this judgment, isn't it?
Yes,
So what
yes,
are
my
the
lord.
facts of the case in this?
The facts of the case, my lord, the facts of the case can be seen from paragraph number 3 of the impugned judgment, my lord.
Huh.
This is her case in brief. The petitioner averting her petition that in 1998, when the respondent's sons, namely Sri Satya Priya Diwan, served as LDC in the Land Revenue and Settlement Department, CADC, he had illegally altered the land area of the respondent.
You all can go. I'll call you later. Yes.
And increase the area of about 6 feet from 24 feet to 34 feet, and recorded in the office record of the Land Revenue and Settlement Department.
Okay, so in 1998,
Yes.
the respondent's son,
Respondents meaning the present appellant.
okay, her son, her son was working in the revenue department, isn't it?
This is the allegation, my lord.
Okay, allegation is that you had altered the landed
Yes.
area of the present respondent.
Yes. And the allegation is that, if we go on to read, my lord,
Yes, please go read.
the respondent encroached of about 6 feet to the land area of the petitioner of LSC number 8 of 88, dated 12/1/88, and constructed RCC building, and thereby deprived the petitioner utilizing the plot. In 2012, when the petitioner went to Delhi, the respondent in her absence illegally occupied a portion of land and started construction of RCC building. Where construction of RCC building,
That means you, isn't it?
Yes, yes.
Appellant had constructed.
Yes,
Okay,
ma'am.
please read.
while construction of RCC building, the respondent neither informed nor sought permission from the petitioner, which in turn the petitioner had substantial loss of her land plot. The petitioner further deposed in her petition that the respondent's house may fall into the land of the petitioner, which is in turn affecting the land of the plot of the petitioner. Further, in 2006, the petitioner allowed the respondent to build a temporary bamboo house and permitted to stay for a period of 1 year only in a portion of her land plot, and it was also agreed that whenever the petitioner starts construction of the house upon her land at that time the respondent shall release and vacate her land. But the respondent constructed RCC building and also constructed a side drain upon the land plot of the petitioner and stayed there beyond the period of 1 year. The petitioner requested him to vacate the land plot on various times and occasions, but he never heeded to her words. The petitioner further stated that in 2017, the respondent tried to construct a pillar under her boundary, and when she objected, the respondent threw a piece of wood 2 by 3 inches to her. He even used savage and slang languages to her. Thereafter, she reported the matter to the Revenue Department CADC, and the department remeasured her land plot and directed the respondent to release her land, but the respondent did not release the same. Again in 2018, when the petitioner went to Delhi, and in her absence, the respondent encroached upon her land and constructed his kitchen house. The petitioner further stated that she had lost her land documents. He even reported the matter to the local police station at Chongte. The petitioner submitted petition to the Revenue Department for duplicate copies of her land passes, but still she did not receive the same. Once the revenue officials clearly indicated the boundary of the petitioner and asked the respondent not to encroach upon the land of the petitioner. In some occasion, the respondent treated the petitioner with dire consequences. The respondent had illegally increased the land area from 24 feet to 30 feet without following proper procedures. The respondent had illegally occupied her land plot, and as such, she prayed to pass a decree against the respondent. Learned counsel for the petitioner submitted that the respondent had illegally encroached upon the land plots of the petitioner, and the respondent had increased his land under LSC number 34 of 83, dated 27/7/83, from 24 feet to 30 feet without following the official procedures of the Land Revenue and Settlement Department CADC. Learned counsel for the petitioner further submitted that behind this illegal activity of the respondent, there is intention and motive, and the nature of the respondents in contumacious and disrespectful, as the respondent had willfully violated the court order despite issuing explicit order from the court. Here, my lord, to avoid confusion, sometimes the trial court arrayed the present appellant as a respondent while in others it had arrayed him as petitioner. Learned counsel further cross-examined Sri Satya Priya Diwan and alleged him for illegally increasing the land.
So you explain to me what are the facts of the
My
case?
lord, the facts are very simple. There was a land dispute between this Snehadi Talukdar and Chitaranjan Chakma. This Snehadini Talukdar filed this case before the judicial officer CADC.
The present respondent filed the case.
Yes, and after she filed the case, the respondent had explained himself, and thereafter the revenue officer, the judicial officer, that is JS Chakma, had called the petitioner and the appellant and the respondent before him and took their statement. But without following any procedures established by law, he had passed the impugned order wherein
Okay, where's the operative part of the order?
the operative portion would be at page Roman 10, paragraph number
Order.
12. After a detailed scrutiny of the case records and a detailed examination of the original land pass records register volume 1 of area Kamala Nagar 1 of the Land Revenue and Settlement Department, CADC, this court has to reach to its opinion that the area of the house site pass of the respondent, Street Chita Ranjan Chakma, dated Chakma of 34 of 83, dated 29/7/83, is not genuine, as under page number 100 of the past record register, there is overwriting upon its area and proper procedure is not followed while making such pass as reported by the concerned department. Thus, taking note of this fact and in consideration of section 10 of the Chakma Autonomous District Agricultural Land Act 1982, this court thereby instructs the Land Revenue Department, Revenue and Settlement Department, CADC, to cancel the above pass of the respondent and issue him a new pass with the area of 24 feet into 37 feet length and breadth and cost weighted measurement of his existing house. If his house encroaches more than 24 feet of the roadside, then the Land Revenue and Settlement Department is directed to order the respondent to vacate the encroached area, and concerned department is at liberty to issue any direction against him as envisaged under section 10 of the Chakma Autonomous District Council Agricultural Land Act 1982. The Land Revenue and Settlement Department, CADC, is directed to collect the original past record register, volume 1 of Kamal Nagar 1 from the District Council Court. Since the land dispute arises due to the existing pass of the respondent and which has been cleared, the said pass has not been made prepared legally to official procedures of the Land Revenue and Settlement Department as per report submitted to this court by the concerned department, and it has been admitted by Sri Satya Piro Dewan that his initial signature matches with the initial signature of the house pass of the respondent. Besides, Satya Piro Dewan, as he claimed in the court, was a dealing assistant of temporary house site passes.
Who is this now? Who are these people? Priyo Diwan
These
Satya?
people, he have summoned and asked for their statement. We are challenging the procedural lapse, my lord. In fact, no issues have been framed by the judicial officer while dealing with this case, and no chances to examine the witnesses were also afforded to the appellant. And in this honorable court, in the case of H. Vandal Roya versus H. S. Rauhaka, decided in the case of RFA number 11 of 2017, decided on 7/9/2017. I've given a copy, my lord, wherein the operative portion would start from paragraph number 6.
But this is a judgment by the civil judge, isn't it? Senior civil judge
Yes, my
Champai.
lord.
This is what, District Council Court?
District Council Court, but the provisions of CPC will still be applicable, my lord.
In spirit?
Yes. In civil court as well, in spirit. As per,
No, not after separation. Civil court, it's no longer, it has to be in letter now.
As per the compendium of laws, my lord. It's in spirit.
You can't take the excuse now when we are under the High Court.
Yes. My lord, as it stands, it's still under spirit.
Where is it? Let's see. Give me the compendium of law. Where does it say? Then you have to show that this is an order passed by the District Council Court, okay? So the District Council Court and the civil judge, even after separation, it has to be the same. Give me those. You have the Civil Courts Act also.
The compendium of law here only.
Give me those material.
My lord, if we're going to that issue, then can we continue it tomorrow? Because I'll be,
Okay.
because
yeah,
I was not prepared that we're going to go into that issue.
No, because you have given me this judgment.
Yes,
Then this judgment is made by the civil judge, senior civil judge.
senior civil judge.
So if I'm not mistaken, one of the points taken by the respondent is that since this is a district council court, okay, the CPC is not applicable in letter, in spirit.
in spirit.
So now you have produced a judgment
Yes.
where the court, by referring to CPC, has said that issues have to be framed.
Yes, my lord.
And you're saying that it's the same, this judgment is applicable for district council court also. Then you have to show that the district council court and the civil courts,
Yes, my lord.
okay,
That
are on stand on
I
the same
will be able
footing.
to produce tomorrow.
Yes.
Because I don't think that we will be going to that issue. Because this is also my case, RFA number 11 of 2017.
You should go into the issue that you should be prepared, because I have just looked at the submission made by the respondent, okay? Their main ground here is that the CPC is applicable only in spirit and all that. All that, those are his main points, that issues need not be framed, okay? Then that question will arise whether, then you'll have to convince the
Yes,
court. You've got a copy of this thing, isn't it, counter?
Counter.
Or what is this which I've just read just now? Written statement on behalf of respondent.
I don't think we have it, because this is in
24th August 2022. What is this? I've just looked through this. Written statement.
No, my lord, I've only been served with a copy of IA. IA number 59 of 2022.
See, you have your appeal, RFA. Then there's another document here. Written statement on behalf of the respondents. So when you look at I've just glanced through now the written statement. The main grounds, he's saying that CPC is not applicable in spirit. Is applicable
letter.
only in spirit
Yes, yes, it's not applicable in letter.
and not applicable in letter. And therefore, those are his grounds which are submitted here.
My lord, I don't think we have received a copy.
How come you have not received a copy? This is 24th August 2022.
I don't know, because my lord, in written statements are not applicable in RFA.
No, it's okay if they're this thing, it's okay. This is in 2022. It was allowed by the court, so they have, it's okay.
So
There's no
I'll ask the
discount.
copy from my learned friend. Then
Yes,
if
give
we
the
can
copy.
continue
You know
tomorrow.
about this?
My lord, at the first time that I was not the leading counsel. Recently, I have received all the brief. I'll check that document, my lord.
So this is there, that's what I'm just saying, okay, and it's here. It's not that you cannot submit in an appeal, but usually the procedure is that once an appeal is there, then it's listed for hearing, and we hear the opposition respondents at the time of hearing.
Yes, my
But
lord.
yes, there's a written statement. This was, at that time, the council was Supreme Raj
Yes, Supreme Raj
Chakma. You were also there, your name is there as Vanlal Shetty.
Yes, my lord. I find
Vishwajoy
power along with you,
Chakma.
my lord.
Maybe he was busy with the political elections, and also maybe he forgot to serve me a copy. And my lord, in my
Supreme
humble,
Raj Chakma.
yeah, in my humble opinion, at least it should be by way of an affidavit, not a written statement.
No, but it is filed in a way of an affidavit,
So
okay?
there is
address.
some
And it was accepted by this court. Filing
nevertheless-
assistant has, so we have to take this as a part of the document.
Yes, my lord. And with regard to whether the
Okay,
judgment,
so for further hearing, we'll listen
Yes.
for further hearing.
yes, my lord.
Well, let's see.
I forgot to know.
You see, previously there was a contempt also.
That has been taken care of, my lord.
You see, nothing, I'm just looking at the order sheet, nothing is mentioned about the written statement which is submitted, but the registry has accepted the written statement, filing assistant has taken it. Okay, so you get a copy of this.
Yes, my lord.
Anyways, yes. Yes, heard Mr. Zoram Chana, learned counsel for the appellant, who has prayed. Okay, Mr. Zoram and Mr. S. Valarsheta, learned counsel for the respondent. List the matter for further hearing on, when do you want it?
Tomorrow, my lord.
Tomorrow is DB, we already
Tomorrow is
have one
DB.
matter, so leave
Thursday.
it
My lord, I think Thursday you have fixed 2 matters for
for a
hearing.
few.
Yes.
We'll fix it in the next week.
Yes, my lord.
Okay, this matter in the, okay, what's the last sentence? This is matter in the next week for further hearing. Yes.
Obliged, my lord.
Yes,
May I please make a mention in item 12 of part 2?
should make mentions in the morning.
I do apologize, madam.
See, in the cost list also, should be at 10:30, what, cost
Yes, my lord. Can the matter be listed after a week, my lord? I have
12,
taken the consent.
item number 12.
Yes,
Your name is not there?
should be there, my lord. I am the lone advocate in this case.
It's 13, maybe you're mentioning item number 13. WPC, is it?
WPC, my lord.
It's item number 13.
My apologize,
You have the cost list with you? It's not 12, it's 13, your name is there.
my lord.
In item number 13, Mr. Rokung Apautu, learned counsel for the petitioner, has prayed for adjournment of the matter. Have you taken the consent?
Yes, my lord.
With the consent from the other side. In view of the work list. When do you
After a
want it?
week, after a week.
After 1 week. Yes.
I'm obliged.